Good, thanks.
Okay. Okay. So you have gone through the materials, no, a little bit now.
Yeah. First of all, thanks a lot for sharing these materials. It's quite helpful. I don't think that, but I think it will be better for me to have a better understanding from you place to place. That might just give me like I'm for the best way to write the answers because I don't really have a structure. I know they always say that you have to follow that word, you have to write the issue and rules. But the difficulty is when I'm trying to figure out the issues and I'm trying to relate those issues to the exact topic of the syllabus and the content. That's when the discrepancy is. So I'm kind of stuck in that right now.
Okay. So if I'm understanding correctly, you're having problem with the structure and connecting the exam topic with the syllabus topics.
Yeah. For example, I'll give you the second question and your 20 questions, which is about the question of that related to. So in this question, when I was going through this part, it says the concern with this would then be submitted as a department recommendation to the federal government. So what comes to my mind as a connection is that because this is a recommendation kind of an investigation, so it will not require a procedural fairness because this does not apply on investigations. If it's a final decision, then we are supposed to apply. But
Correct.
when I go to the answer, yeah. So these are the kind of problems that I'm stuck with.
Okay. Understood. So let me just one second. Yeah, I'll open the file. It will be easier to explain that way.
Yeah, sure.
So first of all, I'll just begin with how to read the question. So when you're reading the question, it is very important to remember each and every fact that is connecting with procedural issue. Now, usually in your exam, they will ask 100 marker question, and that will cover both the procedural and substantive issues. So in substantive issues, it is not going to be a much problem because we know in substantive issues, there are 2 points that we need to check. That is the final decision, right? The decision part, you have to go and read and understand that what fact they have misunderstood, what law they have misinterpreted. These are two things, the mistake of fact and mistake of law. Those are the two things that you will find, and you will find it in where you will find it in the either the report or the final decision or something they would have given it uh, in that quotation basically. So
Yeah.
that is going to be the decision. So you know where to look and what are the things to look. You will be looking at the fact that was misunderstood and the law that was misinterpreted. But when it comes to procedural aspect, that's where most of the students are also finding it difficulty because there are a lot of procedures that needs to be followed. Now, for example, in Aboriginals, we know Aboriginals, whenever the question comes with respect to Aboriginals, we know Section 35, duty to consult and accommodate. That definitely we have to talk about it, right? Yeah. So if it is about departmental, now here you said, as it was, departmental recommendation. So you have to connect it with the topic where there was the situation was similar. And they said that the exception, right? Do you remember the limitations and exceptions of the procedure of the duty of fairness? Let me open this additional notes I
So,
shared. This is where this
yeah.
file will help you.
And also, let me know how to put your material when I am giving this exam, how to utilize the printouts of your material in a way to help me write the answer.
Yeah,
Just
yeah,
this for the
yeah. I will cover that. So, okay. So, our entire syllabus actually starts with the topic of duty of fairness, right? So, duty of fairness is the beginning point. Okay, point zero. So, duty of fairness is, of course, um, comes from the natural justice, but slowly it evolved into, administrative processes. And then there are, two things that the admin body or the ADM has to have. That is the duty of fairness in the two forms. What are those? The principles of natural justice, the right to fair hearing, and the another one is right to an unbiased and independent decision maker. So those all, like duty of fairness and principles of natural justice, those boil down to only two things, that is right to fair hearing and right to an unbiased and independent decision maker. Okay, but we have to dial it back, like going from zero, that is duty of fairness. You have to start your answers with that point itself, where it all began. Nicholson case, right? Nicholson case, you remember? That is where the duty of fairness basically, got the limelight. And they said that yes, it is very important for the person to get duty of fairness when they are in the administrative process also. Before that, it was given and considered as an important factor only in the judiciary, right? So now they come to, duty of fairness. Why duty of fairness is only given to, final decisions? Because it is of such importance that they don't have any other option. So slowly they started talking to us about, in the syllabus, duty of fairness is important. Then they said that yes, there are certain exceptions though, where duty of fairness is not considered. So in your question, you have to first see, is it falling under any exception? If it is, where you have to look at. So it's kind of, it's kind of a checklist thing that you have to do. So if it is coming under any of these limitations, so you will see that, okay, is it a legislative decision? And yes, it is an exception. However, there is also exception. What is the exception of legislative decision? It says that in legislative decision, if it is focusing on only one person, and somebody has given, we have the case of Wyoming case we have, where the, municipality basically gave, brought the bylaws only to affect this one person.
Okay.
Yeah. So
So,
what happened? Yeah, you have
okay,
a question.
so how do you make sure that it's a legislative decision in the first place?
Okay. So how to identify whether it is a legislative decision?
Yeah.
Okay. So you will basically read the question and you have to see whether it has the elements of a tribunal decision or a legislative decision. To identify that, it is there in the facts. If it is a bylaw, if they are giving a bylaw, if it is a enactment that is coming into picture that is affecting the party, if there is a process which says that this person X has filed an application before Y board and they have given the decision, so that is a normal decision. Okay, that is a adjudicating decision, right? There is a application, there is a reply for that, or like a rejection or acceptance of that particular application. But here in the legislative decision, there is no application. There is only one side. One side they are coming and they're saying that from now on, this is the rules. अब इसके साथ
Okay.
रहो.
Okay.
Yeah. So there will be bylaws, there will be rules. So a lot of times in the exam, we have seen the same pattern that these people, NCA people give. That is legislative decision. They will begin, in the in the question, basically it will be a reflection of legislative decision only. Okay, so you have to first identify what sort of decision it is, what sort of exception it is falling under. If it is, first of all, falling under any of the exception, then you can basically point out, a lot of topics, whether it is falling under legislative decision, yes or no. Then move ahead if it is a final decision or not. Okay, so final decision, no problem. It is definitely going to get the attention and duty of fairness. But there is an exception also, that is, recommendation and investigations are not final in nature, but they are also going to get the duty of fairness, because there is a case which speaks about the nature. If it is nature of the decision is not final, but still if it is of that huge importance to the person who's affected by it, if it is talking about his life, his liberty, if any of the starter right, basically, and employment, we have seen, no, employment, that is very much very important. So if you feel like, this person is under the under very much problem, okay, basically, so you feel like we need to help this guy, and in the exam, basically, it feels like cheating, but you have to say that yes, this guy deserves duty of fairness, because agar aapne bola ki nahi hai, to whole entire answer does not come up, right? So yeah, so here this is the starting point. So this is where I would like you to see first before starting your answer. See that whether which type of decision it is, legislative decision or other normal adjudicative decision, or whether it is a final decision or not. Because if you identify, then similarly you can go and write the answer in the same way. Then there is public office holders employed under contract. So there might be questions specifically for this, where they're saying now identify whether this is a employment under contract. Is it this kind of a question? Most probably it will not come in your final exam. 100 marks, they might not get this question, but that is also one of the exception. And emergency is also another exception.
Yeah. So my question is, the way you have pointed out the legislative decision, emergency, or public officer under contract, is it also possible to list the related cases against each one? So I have this as a rookie that when if legislative decision is applicable, then this is the case that I need to mention.
Yeah.
So is is that thing okay for the example?
Yeah, you can actually write cases right there. What I have done is, in these kind of questions, there are 15 questions that are given. Those 15 questions are of different types, and it is covering these important types of, first, the second question that we are opening is considering this recommendation, right? So departmental recommendation, that was actually told in this case, Hatfield case, which speaks about the exception, where if the decision is such important, that is speaking about, I will show you the application of it. It will be very clear.
And also, other cases, say like Nicholson cases there. This Nicholson case, as per the syllabus, applicable only to one particular condition in the question, or it can be applied to multiple conditions also.
Which case you're talking about?
And it's like I'm just giving an example of Nicholson case. Why I'm asking this? Because if in every case is related to only one important point, which is which we are required to mention and point out in the question. Then I don't need to put more focus on one case from different angles. What I can do is against legislative decision, for example, I can just put Nicholson case. So any situation, if I have a legislative decision in my question, I immediately just go to Nicholson and just write it. So something like that, because and that's why I want to understand, is it also possible that one case is applicable into multiple situations of the syllabus, or one case is applicable only to one condition?
Yeah, multiple situation you can actually apply it, but it should make sense. Okay, just that it should make sense in the sense that the ratio of a case. Um, so okay, let me explain
So,
it in a
so by ratio, we mean the terms of the case,
yeah
the
essence of
final case, essence of it.
yeah. So ratio depends upon different situation. Okay, so for example, now Baker's case is used in administrative law. It's used in constitutional law. It's also used in foundation. So for Baker case or Vavilov case, whatever is the landmark case, that will be considering so many different laws, even criminal law also, right? So what happens when you're talking about a duty of fairness? You will only take the portion that out of the whole judgment that is relevant to this portion. So यहाँ पे ratio becomes the topic or the lines that is dealing with only duty of fairness. In another topic or in another subject, another line or another paragraph becomes the ratio, because that is talking about duty of that particular subject matter. So here you don't have to worry too much about okay, what portion I will write, what portion I will leave, because here we have already mentioned. So in these two cases, Queen, Randolph, and Hatfield, दोनों case में, they say that court observed the importance of fulfilling duty of fairness even in the interim decisions and recommendation stages. So this is what the ratio I am, we should focus on for this particular question. This line is sufficient, and this is kind of paraphrase. We have not taken directly from the decision, but this is understood. Like this is paraphrase from both the decisions. But
And this is good enough for the NCA.
yeah, but if you want to write more about this, what you can do is go to this judgment, and you can search recommendations, departmental recommendations like that. If you do word search, you will get the actual paragraph which speaks about this particular duty of fairness to be covered under interim decisions as well. And departmental recommendation is one of the interim decision. No, it is not the final decision.
Yeah.
Okay. Like that you can write. Yeah. So these questions, see in the exam, how my materials you can use, I will tell that now. So first of all, from start to end, read every question that is there in this file and read every answer there in this file, because each question has a different aspect. Yes, of course, the major topics are what? Procedural fairness, substantive fairness. But there are slight differences. Now, in this one, we are talking about departmental recommendation, whether it is applicable there. So in your exam, this kind of question comes, you can directly go here and just copy the rules, entire thing. Rules you can copy. Then of course the analysis also you can just use the same structure. But wherever we are talking about Abraham and here FMB, you will be talking about your actual facts. You can same structure. Okay, so main thing, as I told you, it is talking about like duty of fairness. And in the duty of fairness, if once you check whether it is falling under any of the exceptions or not, okay, first to find out what type of decision it is. Here it is a interim decision. It is not the final decision. Okay, that we have understood. And you talk about Nicholson, because Nicholson is the one where they began to say that administrative and executive decisions also should have some sort of duty of fairness in them. So that's where we start. Then we have to go to Knight's 3-prong test, because that's where they gave us the 3-prong test, which decides whether duty of fairness is required or not.
So when you say, when you mention duty of fairness is bold, it means required. Like, yes, this was required.
Yes.
And it was not given. Procedural fairness was not given.
Yes. whether it is required and it is not given. That is what we are gonna check in the nice 3-point test.
Yeah, but I see the content that the nice 3-point test is, I think, is applicable most of the situations. We know it to so this is like a very important part of it. Whatever the situation is, I mentioned.
This is compulsory for all the procedural fairness. You have to write 3-point test and Baker synthesis. So everybody is going to write that. No, that is where I say, even in my regular classes also, I keep saying this portion is where you're going to impress the evaluator, because this is going to be different in everybody's answer sheet. The beginning of your analysis, before you start even start writing the night's case. That's why I say for my students to write Nicholson, because not everybody writes Nicholson. Okay, it was given in the syllabus, but students don't give much importance to that, and talking about the procedural obligation, duty of fairness in general, and talking about the facts in the beginning itself, in the instant case. So I suggest start with the topic, what it is dealing with. If it is talking about procedural obligation, I start with that general statement, 1 or 2 lines, that's it. Don't talk too much theory in the beginning in your analysis. Then immediately start with in the instant case, what is happening. In the instant case, the procedural obligation is placed upon whom? We are talking about this particular board and the person who is Abraham. So about both the parties you have identified. So indirectly you are saying that I have understood the fact. Okay. So invigilator, that boss, I have understood the facts, I have identified the parties, and these are the people they are dealing with. So this is kind of a eye-catchy moment for you to show.
But in case if my analysis, I have not understood the right point of the issue, and I mentioned that when it's also going across as a periods and contracts, the question.
Yeah. So, but parties you can figure out, right? So there will be one particular decision maker, and on the other side there is an aggrieved party. Those are the 2 people you have to identify out of the facts.
Yeah, exactly. That's like who's the versus the enabling legislation and who's the affected part. So that I think that we can find the kind of problem is something on the issues, like what issue needs to be addressed.
Okay. What is the actual issue? Like this issue, from where it is coming. So usually that issue will be given in your final paragraph. Okay. So final paragraph you have to read twice. So what I do is that, when the question paper is given, I jump to the final paragraph and read that where it is going, where the, facts are finally ending at. So I read this particular paragraph that the tribunal is now called upon to determine whether. So starts from whether, whether is a issue maker, right? So I will be, focusing here, whether Abraham is entitled to a degree of fairness insofar as the departmental recommendations are concerned. So here is the issue. Okay. Even if they have given it in slightly different words also, it will be there always in your final paragraph, what they're asking and about whom they're asking. So I know there is only Abraham that we have to bother about. Even if they have given, Ram, Sham, anybody in the facts, I will only focus on one guy that we are, bothered about. And continuing, the focus is upon the manner in which the departmental recommendation was made and not upon the legalities before the federal military board. So I have the answer to board, or who is the decision maker as well. So decision maker I got to know the aggrieved party, whether he is entitled. That means he is the aggrieved party. Then we also understood the issue. It is about duty of fairness in making departmental recommendation. Okay, so apply this in all the questions that you are seeing. Okay, go to different questions and try this method. And,
this is a great tip actually. I didn't look into the questions this way, but this is a great tip for me. So I go to the last part of the question, and that's where I will understand where the question, where what is they are asking, and then when I am reading the question, I will automatically start thinking from that perspective.
Yeah. Yeah.
Yeah, thanks. This is a great one.
Yeah. So finally, after reading this paragraph, I have understood three main things: that what is the issue here, who's the agreed party, and who's the decision maker. Then I will read the entire fact, because 100 marks ka fact so isse bhi bada hoga, like it will be too much. Okay. And starting say if I read, then some of the things you might forget. Some of the things I might have sometimes it will be too boring also. The 13 paragraph, it will not be useful also in our answer. But 60% of your answer should reflect on the facts. Okay. So it's not like the entire paragraph you're writing in your answer as it is, but you're writing, 2 lines of facts, whatever is important. Now 2 lines I wrote, and then these 2 lines might be important. These 2 lines might be important. Like that, whatever is relevant, those should be reflecting in your answer. Answer may 60% should be from the facts only. So you can see I have written Abraham's name everywhere. I talk about the concept, immediately I talk about the fact. So sandwich method, this is what I call. So sandwich mein jaise, first bread is there, then the patty comes, then again bread will come. No, so like that. So first you talk about the concept, then you talk about the facts, then again you talk about the concept. Like that, kind of like layout you have to do. Should not make just the theory in one para, just the facts in one para. That does not look good. So when you're doing the analysis part, imagine you're in court and you are doing the final arguments. So in final argument, how you will present to the court? You will start saying about what your file is about, what your case is about. You will say that, yes, your honor, this is the case of procedural obligation, and here who is the party? You introduce them. No? So analysis also should be. So then it will go on a flow. So imagine yourself in, and then you're doing, the final argument where you have start and end both. Okay, so by explaining to other parties what is the issue here, then you take, see, it is important to check whether the duty of fairness is owed by the FMB to Abraham in order to determine whether he is entitled to degree of fairness. So degree of fairness comes later. So pehle we have to see whether duty of fairness is owed or not. And for that, we have the test of Knight 3-prong. Okay.
Going to the minus 3-prong, and I will go into the nature of decision. So, like the pre case, mostly it will be applicable. I can just keep it as a fixed paragraph and I can write. Obviously, I will put the fact in from the question.
Yeah. You can use this as a structure of the answer. Wherever is needed, you will be slightly, using the words and all. Yeah, that you will be doing it. Then coming to Knight 3-prong test also. So nature of the decision, relationship between the administrative body and the aggrieved party. Then the impact of the decision on the aggrieved party. So another mistake that the students do is that they explain what happened in Knight's case. You are not supposed to talk what happened in Knight's case because it is an open book exam. They have the material. They know that you have the material. If you write about Knight's case, no, you are not going to get mark. You have to apply what test they gave. That is these 3 lines. That's all. Whatever is highlighted, that is the test. So these 3 points you will be writing from your notes. Only that means you have to copy. Remaining, this is the application. If you see, everywhere I have applied it to the facts of this particular case. So this paragraph is wholly talking about what happened in this case. So nature of the decision of this. So in the instant case, though the departmental recommendations are a part of a preliminary inquiry, where did I get this? This is from the facts only. In the facts it is written. Okay. The nature of the recommendation seems to be having a strong impact on the livelihood of Abraham. This is I wrote. This is what I wrote. Because it is impacting on him. Okay. This you can see for any situation, slightly different question will come in your exam. But if it is about recommendation or kind of an interim decision, you can say that it is affecting on his life, liberty, whatever is given in the question. If it is about section 7, sometimes immigration application and all will come, no? That time you will say that it is affecting at his life, liberty, and security under section 7 of the charter. Okay, so hence the meaning is very important. So somehow we have to show here that the decision, even though it is not final, it is very important to the guy. That is our whole object here in the night stay prong test, because we have to pass all the 3 stages, no, in order to move further. So somehow we will, in the fact, we will try to find that how it is affecting him, how important it is. So nature of the decision, if it is the final decision, deal done. You don't have to go further. But if it is interim decision, then you have to focus on, okay, what type of decision it is, how it is important, and also remember these 2 cases. So what I would suggest is, in the exam, don't write both the cases. I have written both the cases because I have like 5 to 10 students sometimes writing in a batch. So some people should take this case and some people should take this case. Okay. So I have given you 2 options, but in the exam, choose any one case, but both the cases are talking about the same thing. So both the cases will be about, so you can choose the, recent case as well, Hatfield case, that is the 1986 over 1966 case. Then you have now said that, okay, nature of the decision, even though it is not final, is very important. So as per this case also, as per the case, the Supreme Court has confirmed that interim decisions are also important and they are, required to fulfill duty of fairness, even in the interim decision. So duty of fairness yahan pe zaruri hai. It is important. So moving on to the second one. Second one talks about what is a relationship. That's all. Here nothing else we have to prove. Here the decision, here the relationship should be of one of a ADM and the aggrieved party, right? So ADM and the aggrieved party, even in the Knight's case also, it was of the employer and employee, and even here also it is employer and employee. Not every time you will get the relation of an employer-employee or some other relation between the parties, but every time you will get the relation of a ADM and a aggrieved. So at least even if you don't get any other relationship, write that this is the relation between these parties are, one is the administrative party and another is the aggrieved party. Okay, so the decision maker, one is the decision maker, another one is the applicant, complainant, something like that will be there in your facts. So that also again comes from the fact. Third one is the impact. Of course, that will be given in your facts again, how it is impacting him, whether it is, he's losing his job, his, reputation. Your departmental recommendation is a crucial stage. Because of that only he will move further and next, appeal, whether he is eligible for appeal or not. That and all will be, basically given in the facts. So from the facts only you have to take and write here that in the instant case, the departmental recommendations having Abraham suspended is greatly impacting his reputation. So some kind of creative imagination also is required in the sense, writing answers. I would say that, kind of a story writing creativity you need a little bit, at least 2%, to say that, somebody is getting suspended means, of course, his reputation is getting affected, right? So those kind of things. So little bit imagine practically and think that agar aapka client hota, like if you are representing this guy, what would you would the final argument before the court, right? So kind of that way we have to write the answer. Then how much ever you can write, it's not required to write this much big paragraph or something because we have a lot to cover also, but at least give the point that here the impact on the aggrieved party is of grave importance. That is the objective of this whole paragraph should be. And then conclude. Therefore,
is it mandatory that in every question, is it mandatory that the 3 prong test will come just at the beginning of the case, and all the three situations will pass. 100% it has to pass.
No, in all the 100 marks question, definitely this will come. Because three prong is the beginning. Without three prong, we will not be able to establish that here duty of fairness is required, because only when you establish duty of fairness is required and further you say that how much duty of fairness is required with the Baker synthesis. Without these two, we can't say that yahan pe notice was important, here the oral hearing was important. You can't go further and say those things without these two. These are the foundational things. So everybody is going to write these two tests and synthesis because they have it in their IRAC, or they have structure, or just the syllabus material or something. So they're going to write it. But what your answer should look and it should have is that application part. This is where you're going to make a difference. This is the where you're going to make a difference. So make sure you're writing very in an articulative manner and you're putting the right things and applying it to the facts properly. Then, as I said, Baker's synthesis is also very important. But again, some students by mistake they just write that Knights and Bakers each have different things. No, Baker's actually is talking about degree of fairness, means how much fairness is required. Little bit more, too much, the degree, that one. Okay. So little bit medium or more. That is what you're going to say in, you find out in Baker synthesis. Otherwise, one test was sufficient. No, why we are writing two tests? So that
okay, generally, what will be the most important thing that I need to see to figure out if it's like minimum the priority or the maximum importance?
Yeah. Yeah. So we have to make that sure, understanding the degree of fairness, whether it is minimum requirement or maximum requirement, we'll get to know by applying these 5 points to the facts. So if majority is saying, ki, for example, let us see nature of the decision and the process followed in making it. So nature of the decision, you have already spoken in the Knight's case. But here the important part is the process followed in making it. Are they following a process of a statute? Are they following a process which is not written anywhere? It is it something coming out of a practice, common law practice, or what sort of process are they following? That is very important here. Nature of the decision already you have written, so that part you don't have to explain further. Do not repeat anything that you have already written in the exam. Okay, that is something to avoid. First of all, it will waste your time. Second of all, it will also bore the evaluator. Okay. Now, in the instant case, the nature of the decision is being non-binding preliminary recommendation. The degree of fairness could be paid as relatively lower because it is not the final decision. So, if it is a final decision, the degree will be higher. If it is a not a higher, final decision, degree is lower. That is the criteria from the syllabus, But the process that was followed in making the departmental recommendation was not as per the concerned legislative framework. So from where did I get this? From the facts. So facts will be showing you that whether it has followed the procedures from the statute or not. So there is an enabling legislation for all the question, right? There will be an act or enabling legislation given in each of the question. So whenever they're talking about that, give more importance in the facts, because that will be giving certain pointers with respect to what procedures to follow, what is not to be followed, and whether they have followed it or not, you can then apply and figure out. So here, yes, you will be saying that if they have not followed what is written, common law is different, like practice is different, but something that is written in the law, that is definitely need to be followed, compulsory. So if it is not followed, then the degree of fairness is of course higher in that situation. Then nature of the statutory scheme. Here the legislation is talking about, sometimes they will not give the act name. So in this case, they have referred it to as concerned legislation framework. So I will also use the same wordings. Whatever they have used in the act, the same we have to also use. Then this provides a detailed process as a mandate, not leaving as any discretion to ADM. Hence, the degree of fairness is higher. So, if the law say, gives some discretionary power to the ADM in the facts, if it is saying that the decision can be either oral or writing, it is basically up to the board or ADM, then the degree of fairness will be lower because the law trusts the ADM. Law has given such importance to the ADM. But in this case, no, they have not given any discretionary power to ADM. So the law says you have to follow ABC. That means they have to follow ABC. That means degree of fairness is higher. The law itself does not trust the ADM enough to make their own decision. So they have to follow a strict method. They have to follow it. So
So
here also,
in your answer, what I'm seeing is that we are concluding one final thing. So here we are saying degree of fairness is higher. Say if I'm not sure if it's higher or it's lower, can I keep it in a kind of a dilemma and answer like, okay, uh, if there was no discretion, if there was some discretion available to the area, then the degree of fairness might have been lower, but maybe in this case it is higher. Something which is a little vague, just because I'm not sure. So in that scenario, what I will do?
yeah. But yeah, try to do that only in 1 point or maximum 2 points, because out of 5 points, at least you should be confirmed at least for 3 points, right? Because in order to get a majority answer, you should at least be sure about the 3 pointers. But somewhere, one or two places, if you're not really sure, you want to keep it vague, you can keep it. That's not a problem. But the no known things like the final decision, then it is the higher degree, that and all right? So make a list of those things where you know that where you definitely know that the degree of fairness is higher. Make a list of those things. So if that is coming in the exam, you can surely write that it is higher. So as and when you're going through different types of question and answers in this particular file, make a list of those things. Wherever I have said, this is the reason why the degree of fairness is higher. So make a list of those things. It will be helpful in the exam. Then the importance of the decision to the individual. Again, so here it is, suspension of it is leading to termination and also dealing with his professional interest. So degree has to be higher because whatever related to job, of course, this is nowhere written in our, syllabus in a direct way. But out of what we had learned in the syllabus, we should understand this much. If it is dealing with any of the charter rights, if it is dealing with any of if it is dealing with your job, so then it is of higher degree of fairness is required, because it is very important to a person for his livelihood, right? To live and work. So all these things are very important for a person. So we have to consider that time high degree of fairness, because anything related to my job, my reputation, my life, it has to be given such full degree of fairness. Whatever is required, you give me oral hearing, you give me independent, decision maker. All these things are definitely need to be given because they are dealing with such important things.
Okay. So the question is, so we know the charter rights, if the charter right is a federal, if it is a federal scenario, then I can consider rid of rights in that scenario. So the both things will be applicable during the field and the process as well as papers synthesis, or just the paper synthesis.
Both will be applicable. Yeah, both will be applicable, even if it
Because
is.
I think charter and I have understood charter properly, but their right, liberty, and security are protected. So in when charter happens, but in a survival scenario, then rights will be there. And with the rights, there will be an additional right, which is property. So that is the differentiation in my mind from and legitimate expectation also a little bit like there is a kind of any expectation. But I think it's a common point. How would that go if common law is applicable here?
Okay, how 3 prong is applicable in the situation where charter violation has been done. Is that your question? Because it's bit disturbance is there, I think.
Yeah,
So
so the one question is, my exact question is how do I know common law is
okay, how do you know common law is infringed?
yeah, that we keep talking about the common law because
Oh,
charter is simple. Like if I see right liberty
correct.
security, I can get charter.
Yeah.
But
But
I don't
yeah,
know about that.
so common law you should know because okay, common law is the case laws. Okay, so case laws, that means whatever case laws you have understood in the administrative law syllabus, only that much you should focus. Outside of that, they don't expect you to, know all the common laws, all the judgments. Okay, only in the syllabus. So other than Knight case, Nicholson case, Vavilov case, we have newly that music composer case, Hekshana's case. These are the major ones. But other than these also, in my answers also you will see, Hatfield and Queen case, Wyoming case. So these are the syllabus cases, right? Syllabus cases you have to give more importance and only understand those common laws. That is sufficient. If anything, is reminding you, like when you're reading, anything is reminding you of the syllabus material, then that means yes, you have a case on that. You have to figure out now which case was that. So I have sent you the, flow chart, no?
Yeah,
In the
yeah.
yeah, in the flow chart, actually, there are the case laws as per the chapter wise. Chapter wise, the case laws are given for the important ones. Yeah, Knight, Kent Institution, Cardinal. So these are the cases that you need to basically study.
Okay. Yeah.
Yeah. Then importance of decision to the individual we covered. Then coming to legitimate expectation. So there are now two ways of writing legitimate expectation. One is that when you're dealing with a Baker synthesis only, you explain everything that is in the case about legitimate expectation. Sometimes there might be a expectation of a by way of promise by the ADM, sometimes from the past practices, right? So uh, different ways of legitimate expectations are there. So if you see in the additional notes also, you can see there are different sources of legitimate expectation from where it is, right? So you can see, is the statute telling that this is the procedure that needs to be given? Now, in your exam question, if there is a law enabling statute and they have told that this enabling statute under section 5 says that the person should get a oral hearing, that is a statutory legitimate expectation, right? So you have to identify and write, okay, what type of legitimate expectation is present in this particular case. Is it from the past practices of the ADM? The question may say that, you know in the agency previously they used to do oral hearing, now only this new guy came and he is giving written submission only, he's accepting. So is it wrong? Is it good? Is there a legitimate expectation from the claimant? Yes, of course, because past practices also is one of the sources of legitimate expectation. Then promises, common law. Common law is, of course, if it is talking about some, case scenario like based on the reasonableness and procedural regularity. So this one um will basically say that in a situation where duty to consult and accommodation is a very good example for common law because under Haida Nation case, okay, under Haida Nation case, it was reaffirmed, it was confirmed that duty to consult and accommodation must be given for all the Aboriginals whenever they are, they're it's not just a court, right? So they knew under Section 35 courts have to give, but we are talking about administrative decisions here. Administrative decisions also should have duty to consult and accommodation. So Crown, or here we are talking about the ADM, they have to give duty to consultant accommodation because from where did we get it? From Haida Nation case law. From like that only some other case might give you um, like Hatfield says that the interim decisions are important. They're also important like that. So if any of the case laws is giving you a procedure that is promised to you, so there is a legitimate expectation because there is a Supreme Court judgment which says that there is this particular procedure. Okay, for Aboriginal actually you can write this one. Then constitutional protection also. If charter is saying that right to life, liberty, security is there, Section 7 is important for you. Then religion, right to religion, like in Arnest case, it was regarding right to religion. So charter issues, if it is coming, that will come. But most of the time in your exam, it is the first three that will be questioned most of the time. Then coming back here, so you can write here with respect to what is the type. Here I've written, the statutory mandates as provided under the concerned legislative framework creates legitimate expectation from the board by Abraham. So he gets this expectation because there is a law itself says that there has to be this particular mandatory like procedure is there, which they have not done. So his expectation is valid. And of course, when the statute says the expectation, then it is higher degree of fairness. Yeah. Also, choice of procedure. If the choice is given to the ADM itself, then lower degree of fairness. Okay. If the choice is not given to the board, the ADM, then the higher degree of fairness is required. Then out of all these 5 points, you will see the majority. Here, of course, all the points are saying about higher degree. And I've highlighted everywhere, degree of fairness is higher or higher degree of fairness is required, so that it gives me an idea. I don't have to read everything again. So there only I will either underline or write it in bold. In the exam, if you don't have that much time, you don't have to do all this makeup but at least give choose a proper font and justify and line in the beginning only you set it so that it's very neat. And at least the side headings, at least you are underlining or writing it in bold. So those are the basics. These are like examples. So then small conclusion saying that whether your higher degree of required or lower degree of fairness is required. Most of the time in the exam, again I say, administrative law feels like cheating because we know what we have to write now. So like here also you're saying that we have to say that higher degree of fairness is required because to move forward, with our answer. Yeah. So majority will be most of the time, like 99.9% of the time has been higher degree of fairness because they want us to discuss about the problems. So yeah. Then here this is a 20 marker question. So we basically had to say whether degree of fairness is required or not. Only that much we had to say. However, we need not explain further into what type of procedure was owed to him and was not given. So applying that, this is a additional point given to you. Now what is that that he had he was owed, so he was entitled for. Applying the above findings, we can determine the degree of fairness entitled by Abraham, that is right to be heard, to be fulfilled by the way of providing Abraham an opportunity to present his case as per the concerned legislative framework and common law precedents. So right to be heard should be given. A proper hearing should be given to him. Then what else? Access to recommendation. That was not given to him in the question. Most of the time, these are the kind of arguments that will be given in the question itself. Abraham is the complainant. He will be complaining about something. His application will have certain pointers. In the question, they will give you these points. Okay, he will be whining that okay, they didn't give me this one, I didn't get this one, I want these things. So it will be written in the facts. So you have to basically differentiate and find out those things and list out here. Okay, these are the things he was owed and he should have gotten.
Because maybe I don't have a style of writing that there is or vocabulary to put it so crystal clear the way that you have put it. Uh, so I don't know like, if I'm up to this point, finally here I'm just concluding. So language that I'm using, can can I try to put this like something like okay, I can just put that and like put the placeholders like okay, ADM or situation and
Mhm. Yeah, yeah, you can like conclude in a different manner also, your own wordings. You can conclude in a different manner, saying that from the facts, whatever you find, on that particular point of time, whatever you can conclude, yes, here, of course, the degree of fairness is over and the degree of fairness is higher. So when the degree of fairness is higher, always uh, we are concluding that he has to be given proper opportunity to be heard. Okay, that comes, and he needs to get the access to this material. That is what he has complained in his application as well. So like that also you can conclude, or you can directly say that this conclusion. And conclusion, always keep it short, 2-3 lines maximum. And in the conclusion you are basically answering direct answer to your issue. Direct answer to your issue should be in your conclusion. You are not supposed to take any new thing and explain in the conclusion. Okay, only you are writing direct yes or no kind of answer for your issue. You will be putting it in the
so
analysis.
for a 100-mark question of the conclusion, it will be in the end, like just one time. It's not when I'm applying the free-form test, then I put a free conclusion there. After papers, I put a conclusion. Not like it has to be just one conclusion at the end of the answer.
Yeah. So after Baker, we have put just the Baker's conclusion. It's like a short one-liner conclusion we have put, whether degree of fairness